Well, good morning, everyone. My name is Carolyn Knowles, and I am the Interim Director of Development and Alumni Relations at USF School of Law. Thank you for joining us for this webinar. IP Verdict Showcases $9.6 million jury verdict against Coca-Cola Company with Jordana Thigpen and Doris Cheng. There are just a couple housekeeping items that I have before we begin today. The first of which that for those of you who have joined us today, we've automatically muted you just because of the number of folks who are joining us. We would love for you to participate, though, in asking some questions via the Q&A feature. At the end of the discussion with Doris and Jordana, there will be a time for Q&A. We might not be able to get to all the questions, but we invite you to please participate in that way. This is also being recorded, so please know that this will be sent to you after today's webcast. So thank you for joining us. With that, I would like to introduce our two participants, our two speakers. First of all, USF Law alumna Doris Cheng. She graduated in 1996 from the law school and has been ranked as one of the top 50 women lawyers and top 100 lawyers in Northern California. She is a partner at the law firm, I apologize if I butcher any of these names, Doris, Walkup, Melodia, Kelly, and Schoenberger in San Francisco. She's obtained 7- and 8-figure settlements and verdicts on behalf of catastrophically injured plaintiffs. She is the current president of the San Francisco chapter of the American Board of Trial Advocates and is the immediate past president of the Bar Association of San Francisco and the Justice Diversity Center. Doris is an adjunct professor here at the University of San Francisco School of Law. She has also taught trial advocacy at the University of Notre Dame, Emory University, and the University of California, Berkeley School of Law. Doris has co-authored several books that focus on civil jury trials. Jordana Thigpen graduated in 2004 from the law school and is now senior counsel at Johnson & Johnson, where she focuses on complex business litigation, entertainment, and intellectual property litigation. At USF, she was a founding member of the USF chapter of the Equal Justice Society, served as vice president of the Student Bar Association, and received the Edward J. McFetridge Award for Excellence in Advocacy. It's interesting to note that Jordana first met Doris at USF when she participated in the San Francisco Trial Lawyers Moot Court Competition. I hear that her team did not win. They lost on a non-suit, but it was a really valuable learning experience. Yeah. After law school, Jordana clerked for the Honorable Ronald Evans Kadachi in the San Francisco Superior Court's Law and Motion Department. In 2004, the San Francisco Board of Supervisors appointed her to the San Francisco Small Business Commission, and in 2006, her fellow commissioners elected her to serve as president. In 2008, she was named Small Business Advocate of the Year by the San Francisco Small Business Network. Jordana was appointed by then Mayor Newsom to serve as the executive director of the San Francisco Taxi Commission. During her tenure, she established the administration of the city's historic hybrid taxi legislation and successfully prosecuted dozens of individuals accused of misusing city permits and exploiting hardworking members of the San Francisco taxi industry. Since 2009, Jordana has obtained over $265 million in settlements and verdicts for a diverse array of individuals and entities, both public and private. Welcome to both Doris and Jordana. Thank you so much for having this conversation with us. I'll hand it over to you.
Thank you. Good morning and welcome everyone who is joining us. It is such a pleasure and really a joy to come back to the University of San Francisco, even though it's remote and we're all trying to physically distance from each other, but not socially distant. And so it's great to see Jordana here in your lovely digs. I have the background of USF, and it's just really great to see you again and see how much you've accomplished.
Thanks, Doris. It's so great to be here. It's such an honor, too, to be interviewed by you in particular. As mentioned, we met in a moot court competition, and it was very embarrassing. It was at the beautiful Ninth Circuit Court, and my team lost because there was a motion for non-suit, And so ever since then, I have been very careful never to have a non-suit granted against me. So it just goes to show you that you absolutely do learn from these programs. It is such valuable experience for students to participate in these. It gave me a foundation as an attorney. So thank you for your service to the university.
And you were also part of the intensive advocacy program.
Yes.
Too. And you were one of the award winners.
I did. I won an award. It was a criminal trial that we did. In fact, the defendant, I was the DA in the case, and the case involved a gentleman that drank Boilermakers, which none of us knew what that was at the time, which now as attorneys, we all know what that is. So that was a great experience as well. You know, just really immersing yourself in trial advocacy. It was invaluable. I can't say enough about that program.
Well, like I said, it's an honor to be back with you and to hear about this great trial. I mean, first, USF School of Law has had this fantastic tradition of intellectual property law. And we have the annual symposium on intellectual property law. And for a long time, there was the Thomas McCarthy Department for Intellectual Property at USF. And so I want to ask you a little bit about this case, because the case that you prosecuted down in San Diego was under Civil Code Section 3344, which is not a very well used statute.
Sure.
So tell us about that.
Sure. So first of all, the statute was 3344.1, but that's okay. It's a companion to 3344. So 3344 concerns the right of publicity for living people, whereas 3344.1 is the right of publicity for deceased personalities. Okay, so what does the right of publicity protect for us? Well, the right of publicity protects against commercial misappropriation of identity, right? So the very essence of what it means to be a human being, your name, your voice, your signature, okay, your likeness, right? And actually the statute for living people and the common law claims for living people have a little bit broader rights. For a deceased personality, there are specific requirements. In particular, there has to be commercial value at the time of death of the personality. So in this case, the personality was called Hubert Hanson. And so a lot of people, especially if you grew up in California, a lot of people know Hanson's soda, Hanson's juices. So what a lot of people may know after this case, I'm sure, and people that grew up in California as well, knew of Hubert. He was the founder of a family of entrepreneurs. And he himself was really just an extraordinary man. Hubert was very successful in his home state in Minnesota. And during the Depression, he lost everything. So very similar to what's going on now at this time, where you see people in crisis and they're having to make fresh starts. And a lot of people did that during the Depression. A lot of people, they had no choice. They had to move forward with their lives. And that's what Hubert did. He came out to California and he made himself into an unbelievable success, pioneer in the juice industry. And that's what he was. And the defendants in this case, they misappropriated Hubert's name to use on products and for purposes of advertising and selling products.
And the defendants were not small individuals. I mean, this was Monster with what we really recognize as the energy drink, and then also Coca-Cola. And so tell us how they became involved.
Yeah, so Hubert started his business in 1935, and he passed away at a very untimely age. You know, he was only 59 years old. He died in 1951, really at the height of his success. Came with nothing, and by the time of his death, he had built up an incredible business. He had manufacturing plants, and he was delivering to studios. He particularly would go around to studio lots. He had contracts with all the major studios, right, in the golden age of Hollywood. And he would go around and he would sell juices there at the studio lots. So he had a lot of famous clientele, but he was also very well known in Los Angeles and president of a trade association, et cetera. And after he passed away, his sons continued the business. He had 4 sons, and they continued the business. And then one of them, his grandson, Tim, who was one of our clients, Tim started his own company called Hanson Foods. And Hanson Foods is the one that pioneered Hanson sodas and what are called shelf-stable juices. So these are juices that are in the bottle on the shelf, as opposed to being fresh juices that you might buy at a juice bar or something of that nature. And so, unfortunately, Tim's company did go into bankruptcy. Interest rates were very high in the 1980s, and he was doing great. He was doing amazing, right? Everybody knows Hanson soda is very well known, especially in the 1980s. It's really the natural soda, a soda that's good for you. But unfortunately, he had to go into bankruptcy. And Monster, the predecessor to Monster, the founders of Monster, they bought some of the assets out of the bankruptcy. And then they started Hubert's Lemonade, which is where the misappropriation occurred, in 2010. And they sold that brand to Coca-Cola in 2015. So that's how those two became defendants.
And the family didn't even know that their father's story or likeness was being misappropriated until I think one of the granddaughters saw an advertising on a bus or something that went by down in San Diego.
That's right. So it's a very interesting area of law because, in a typical case, you have a statute of limitations. And of course, there is a statute of limitations that applies to these types of claims, these statutory claims. There's a theory in civil law as well, the doctrine of continuing accrual, continuing harm. You also have the concept of delayed discoveries. In other words, if you don't know something has happened and you couldn't have reasonably have discovered it, the statute of limitations can be extended. But in this area of law, you have something called the single publication rule. And that rule comes from the case of Christoph versus Nestle. So what that case provides is that if you have one publication, and it evolves from defamation law. So in other words, you have one newspaper, one book, right? There shouldn't be unlimited statutes of limitations. You don't have 5,000 claims. You don't have, 5,000, bits of damage, lawsuits you could file, right? Or in the case of a book, it might have been published once and then it sat on the shelf, right? And then it was going out over time. So, defamation law goes back hundreds of years on this point that, we just want to kind of stop the claim at a certain point. Well, in the case of the single publication rule, you have, and it's an affirmative defense for the defendant, you have a defense to the defense, and that's called republication. So if they continue to publish the defaming here, the infringing content, then the statute will run from each time. And that was a major issue in the case, actually, is this doctrine of republication. We had a jury instruction on it. It was a very important issue in the case. But yes, the clients, they, saw the, what are called the field marketing trucks. And they also saw some of them on the shelf. And that's when they realized this was going on. And then the grandchildren banded together. They formed a trust, the Hubert Hanson Intellectual Property Trust. And then they decided to prosecute the claim.
So, when they first saw the truck, did they even think that they had any kind of claim, or was this, their father's story became well known just by virtue of his, the legend of Hubert Hanson. And so what made them think, or what made them come to ultimately your firm and talk about, this doesn't sound right. There's something that we lost here.
Yeah, that was discussed at the trial, actually, is the fact of when people discovered. People had different points in which they discovered. So a lot of people don't understand this right of publicity. It's something that it does descend. There's actually a scheme, a statutory scheme set up that allows for who it descends to. And anyone who controls more than 50% of the right of publicity, that person controls 100%. So you could have somebody that has 51%, and that person can then license that right of publicity and can decide what to do with it. And in this case, each of these grandchildren had different percentages. So they had to band together in order to move forward with a claim and decide that, this is something that they wanted to do. And that's eventually what they did.
So as far as the claim went, once it got started, this was, these are two major corporations. And I understand that discovery was a knockdown, drag out bear, and that you were actually awarded about 150,000 in sanctions. So
Yeah.
tell us about that process. I mean, those challenges.
The judge referred to the process of discovery in the case as a charnel house. And so for anyone who doesn't know what a charnel house is, I recommend that you Google it when you have not recently eaten. It was a slaughterhouse, essentially. It was very difficult. You know, moving for sanctions is something that we are empowered to do as attorneys. Personally, I do not hesitate to move for sanctions in my cases because I believe that the rules are there to be followed. And if people follow the rules and they provide the discovery that they're supposed to provide, then we will have a just result. And when people do not do that, then there is a process to hold them accountable. And that's what happened. And unfortunately for the defendants, they did not learn after the first motion or the second or the third. And eventually they were held accountable with issue sanctions as well. We actually ended up moving for partial terminating sanctions as well, which is the Discovery Act contemplates this sort of escalating sanctions to deal with these types of problems where you have a recalcitrant defendant who does not seem to be learning from their mistakes, to put it diplomatically. So that is what we did. Eventually, we asked that the statute of limitations affirmative defense be struck, and our judge, we had a wonderful trial judge, Judge Taylor in San Diego. He was not willing to do the partial terminating sanctions, and I understand the reasons why. It's a very, very dramatic remedy. And in the 4th District, it's a little bit more difficult with the standard for terminating sanctions, even partial. So we accept that decision, so.
How did it actually get to $150,000 in, was it sanctions, attorney's fees, or how was that calculated?
Yeah, so there was attorney's fees. We had to spend an inordinate amount of time sorting through a lot of the discovery that was provided to us due to the format that it was in. Another significant issue in the discovery battle was that a very, very large percentage of the documents had been declared attorney's eyes only, which prevented us from being able to share them with our clients and discuss them with our clients. This in turn frustrates the possibility of settlement. It frustrates the ability of the clients to prepare for trial, and it frustrates the ability of the attorneys and of course the court as well that's dealing with all these under seal documents, et cetera, to really adjudicate the case in a fair and an efficient manner. So, we made our motions and we supported them, and believe me, we didn't get all the actual fees that we had spent. However, now that we've won, we will be applying for attorney's fees, and of course, we'll be deducting that $150,000 that we won.
That's such a fantastic result. I saw in one of the motions in limine that, one of the things that the defendants wanted to do was that by declaring these documents as attorney's eyes only, that you'd have to clear the jury room every single time you wanted to do a presentation or use that exhibit. And what was the court's response to that type of request?
Yeah, the court, this is a really, I've contemplated doing some writing about this. I think I'm going to write an article for the Daily Journal about this. It's a significant issue because you do have cases where you have trade secrets or patents or, the formula, right? If the formula of, Coca-Cola or even this lemonade, Hubert's lemonade, had been at issue, certainly that type of intellectual property of this company, that's something that, by all means, they have the right to protect that. But I feel like this is going to be an issue more and more as we go through another decade of evolving technology and an evolving situation where we have clients that have spent millions of dollars on research and development, right? So in the case of these documents, ultimately, this was not a procedure that the court was inclined to adopt for these old marketing materials and older financials. They weren't rising to that level. But it's a significant problem for justice because we do have a right to open courts in this state, in this society. That is a policy that is important to us as members of a democracy. It's a significant problem that we have to deal with in our profession as we go forward.
In fact, your trial finished on Valentine's Day, and just a month before our shelter-in-place orders, at least in the Bay Area, hit. And but you had like 51 witnesses, and a number of them were by video. And looking at today and how we're thinking about resuming jury trials, how we're going to get people into the courtrooms, even witnesses, tell us a little bit about your thoughts on how it went using the video feature in the courtroom, and how you think that might change today, given all of our issues with social distancing within courtrooms.
Yeah, as soon as this started happening, this crisis, that was one of my first thoughts is, thank God we were able to finish this trial when we did. And, due to a number of factors, the trial had been continued a couple of times. And so this was just kind of the final time that it could be continued to. And had it been continued anymore, obviously it would be a significant problem. It is going to be, I don't know how we're going to handle this. And it's a dialogue that we're all having. I'm a member of the California Lawyers Association litigation section, and it's just been a major topic for any trial attorney, because the right to a jury trial is, again, a pillar of a democratic system. And in the criminal and the civil context, some cases have to be tried. I mean, they just do, and it's not a failure of negotiation. It's not a failure of the lawyers or the clients or someone. I mean, sometimes people are unreasonable, but some cases have to go to trial. And it's a big problem. How are jurors going to feel safe?
Let me ask you about the witnesses, since you had, like I said, 51 witnesses, and some of them were by video, or was it some remote application? But what did you do with those, and how did you feel about the being able to show the credibility of those witnesses, or being able to cross-examine them?
Yeah, so we deposed, we had 65 depositions in the case that occurred in 2019 over a fairly condensed period of time, all things considered. All the beneficiaries and their spouses to the trust were deposed, and then there were many employees of defendants that were deposed. The video clips from those depositions were what was shown at trial for those witnesses. It's difficult because the jury had to watch a lot of videos, right? And so, then you try to fit them in. You try to do your case, present it chronologically, but then sometimes, you've got, I've got 48 minutes and I got a 45-minute video. So I'm going to put it in, you're going to slot it in. I mean, you're just looking for ways to kind of keep the trial moving efficiently and meet the trial judge's expectations and the jury's expectations. And then also you don't want to put just, 4 hours of video, but hey, I mean, sometimes we had to do it because there's just no other option. Nothing can take the place of a live witness in trial. I mean, the jury is entitled to consider the credibility. This is a significant problem for now videotape depositions. Somebody could be putting answers up on flashcards, right? While they're there sitting for this video deposition. So now a person has a perfectly coached trial testimony, because there was a video that was perfectly coached, right? It's going to be happening. So this is a significant problem as well that we have to deal with. We're going to need to have some type of system to ensure that this doesn't happen. And I'm not sure what that looks like yet, but I'm certain that technology will evolve to be able to do that.
So with your videotape depositions, because that was pre-pandemic, yours were like you were in the same room, or certainly the court reporter was in the same room. So yes. There was monitoring or ways to monitor the witness, right?
That's right. Both of us, we took them in our office, and then we were in 8 states, actually. There were 8 different states, members of my firm, took these depositions all over. Each side had 5 experts as part of these depositions. There were 10 experts in the case. We had an amazing team of people. I have to say something about the trial team that we had and my firm. We had Neville Johnson of my firm and Basile Hamida. He was our co-counsel. He does a lot of right-up publicity cases. And Jordan Gonzalez, an associate at my firm. Without Jordan, this case just could not have been possible at all. She worked right alongside me. We worked 7 days a week to put this case together, literally. I think we had a total of 4 days off the whole year last year. It was just, it was a very grueling process. We also had a jury consultant too, Harry Plotkin, who was amazing, who helped us pick out a jury. He's a very well-known jury consultant. Just the value that could not be underestimated. And we had a trial tech as well, Litivate of San Diego, Daryl Exline, amazing. And I have to say something too, for all the students out there, your value as a student participating and helping prepare for trial, it is invaluable to have younger people. Some of our best people, our best and most insightful things came from people in college, just about to start law school, in law school. They bring a fresh perspective, and it was so valuable to us. We had a really great team. This case took a village. It truly did.
In fact, let's look at some of the trial things that you had. And one of the things you had, a trial exhibit that sort of capsulized the case. And then if that's something you can show here.
Yeah, let me see if I can share my screen here, and I'll show what was at issue in the case.
And as you're thinking about that, I also wanted to talk to you about one of your favorite parts about the case was closing argument. And of course, we want to know about your trial themes and some of the analogies and fun things that you got to infuse in there.
Yeah, so it looks like the host disabled screen sharing. So I will, let's see if I can get that to work in a minute. But yes, let's talk about okay, let's see now. Let me, okay, now I can do it. So let me just put this up right here. Can you, let's see here. Okay. All right, can everyone see this, this exhibit 704 here on the screen?
Yes. And this is the backside of the Hubert's Lemonade, right?
Yes. So this is what was at issue in the lawsuit. So the issue concerned the misappropriation of Hubert's name. As you can see, a lot of people know Hubert's Lemonade. It has a winking lemon on the front. It's a bright yellow icon, and it says Hubert's in a script font, which was meant to look like handwriting. And so here you see this is an exhibit that was displayed at the trial. This is just a screenshot really of the background of the lemonade bottles. And as you can see on the left here, this is the script. They call it a romance story or a romance copy. If you look at bottles or products, you'll see, and there's a lot of products that are named for people, some living, some real, some deceased, and some made up, right? Yeah, I did a lot of research on that actually, of all the different products out there that are named for different people. It's really interesting. So, but here they are talking here, and they put a story about Hubert and what he did, right? So when life gives you lemons, you get a big truck. In other words, this is what Hubert did. This is literally what he did. He went around to the studio lots and he sold juices. And so then on the left here, you see there's a quote, "Only the best will do, Hubert Hanson, founder," right? So the idea was that here's Hubert's Lemonade, it's made by this person, and, you should purchase it because it's a trustworthy and a quality product. In fact, Hubert was not the founder of Hubert's Lemonade. But the falsity of the representation for legal reasons, that's not really, that's just not an issue. The issue is that Hubert's name was misappropriated on this bottle and used to start a brand.
And so when Monster had purchased parts of the Hanson products during the bankruptcy, or out of the bankruptcy rather, they never, first of all, Hubert's lemonade didn't exist. And what they got was the Hanson's trademark, but that is different and separate than the Hubert Hanson story or Hubert Hanson name. Is that right?
That's right. So the Hanson's trademark was actually held by the company that was, Hubert's sons had continued. So Hanson's Juices was that company. Hubert's company was a different entity. And then in 1973, Hanson's Juices was incorporated and the sons were operating that company. And so the Hanson's trademark was the subject of a series of contracts that occurred starting in 1992 and continuing on until approximately 2004. And it was a subject of a trust. And so, yes, the Hanson's trademark, there's no question that that's owned now by the Coca-Cola Company after the sale that happened in 2015. That was not at issue. But the right of publicity is wholly distinct from a trademark. It is wholly distinct from a copyright. And those were major issues in the case that the defendants attempted to argue that, no, it passed with the trademark, or it passed with the copyright, or it passed it with these contracts, or we had a license. There were a number of different theories that were argued and they're either legally incorrect or that are factually incorrect based on the record, the actual record.
I mean, the essence of what the family was complaining about was that Monster and Coca-Cola had used the name Hubert Hanson, and they had used the term Hanson or Hubert Hanson founder, and that text about only the best will do, and then the personal life story. I mean, everything that's really encompassed just on the bottle, right?
Right.
And so tell us how that turned into a $9.6 million verdict.
Yeah, so a lot of people don't know about the business of publicity licensing. So this is a whole area of the law in which you have people's publicity, that living people and deceased personalities, their publicity rights can be licensed to use for products, for advertising, really for anything. Even animals, there are a number of animals, like this cat, Grumpy Cat or something like that. These types of animals, people get these animals and then they want to have them on merchandise, etc. Those animals, can have publicity rights and be licensed, and these individuals can make money. Certainly, it's not, I wouldn't say it's going to fall under 3344 if that happens. I think that would probably be more under like a trademark claim. There have been a number of cases involving animals. Now there's even some cases involving AI and whether AI can have a publicity right. It's really going to be interesting, especially with AR coming up and all these different things in the next 10 years. If we survive our technological adolescence, as I like to say, it's going to be very interesting to see the evolution of the right of publicity. But the way that people make money is by licensing it. And so typically the way these deals will be done is there will be a percentage, a royalty percentage that's paid on gross revenue. And that's exactly what our expert, Professor Faber, an amazing licensing expert who lives in Indiana, which you would think, why Indiana? Why not New York or LA? But Indiana actually has a essentially perpetual right of publicity. And he was instrumental in working on the legislation there. So that's where he's based. And so he opined that the royalty rate should be 5%. The jury eventually decided to award 3.5%. And then that's one of the components of damages. There's also profits. In other words, you can get profits that are not already taken into account when computing actual damages, the actual damages being the license fee. But the jury declined to award profits, and that was the decision that they made based on the facts that they had.
So tell us a little bit about the closing arguments, and like I said, what were the trial themes, and what were some of your favorite analogies that came out of that?
Yeah, so the closing argument, I had a lot of favorite parts of the trial. I think one of my favorite parts was just kind of managing and controlling the whole thing because I just love to put puzzles together. I just love to put pieces together and to have an efficient operation. I wasn't 100% efficient the whole time, but that was probably my favorite part. And the closing argument was my second favorite, because it's just such a great opportunity to put everything together and to explain it and to just lay out this case for the jury. It was very complex. I mean, it was essentially a bar exam that you're asking these 12 people to take. You know, this case involves so many legal issues, just everything you can imagine, not just right of publicity law, contract law, you know, and they were arguing copyright to this jury. They were doing all kinds of things. So it was a challenge to put together a closing argument that could be efficient and succinct. But, you know, our theme was essentially that, listen, the facts are what they are, you know, and I felt like we needed to trust this jury and to treat them like the highly intelligent people that they are, the people that know right from wrong and know that you don't just misappropriate a right of publicity that does not belong to you, you know, and especially in the wake of evidence at the trial that they had specifically negotiated for the right of publicity with other acquisitions that they had done. And the same attorney actually had drafted those contracts. They had acquired two other entities, Blue Sky Natural Soda and another entity called Pasco or Junior. It was these junior juices, kind of like juice box for kids. Those contracts contained the right of publicity. And we were able to find reference to those in their 10Ks. So, you know, I can't express any more. You know, it's so important to just know everything that you can about your case and to go very deep on the internet and find everything you possibly can. You know, just, you have to immerse yourself completely. That's how we were able to find a lot of these facts, by doing intense research.
And so how did you get the jury to care about, you know, this family that does seem to be well off? I mean, it doesn't, you know, when you hear the Hanson name brand, you connect it with the soda, you know, you don't think about it as something relatable to the average person. How do you get them to care about the fact that there's a right of publicity and that something actually got taken from them? Sure.
So first of all, there were 16 different grandchildren, and virtually not all of them testified in the second phase, but quite a few did. The first phase, I think I'm not sure if we had everybody. I think there was a couple that were missing just because of medical situations and whatnot. But, you know, listen, I mean, the family is not all well off. You know, Tim had this company, but, you know, he went bankrupt. And, you know, everyone has always had a great attitude of, you know, and this was passed down from Hubert, that you're just going to work really hard and you'll have success. And that's what Hubert was about. And I think that the jury was struck by the fact that, you know, Hubert had done this. He had made this success of himself. And the defendants thought to themselves that they would just help themselves without actually doing the due diligence and ensuring that they did have these rights to use his name in this manner. And they had taken something that didn't belong to them. And that was, I think, significant for the jury, is that there was just either, whether it was a negligence or it was an intentional act, you know, there was no punitive damages in the case. So, you know, whether it didn't matter. It's, you know, you have the superior ability to do that. You have a stable of attorneys to do that. You have this ability, and you didn't do it. You know, that was argued, an argument that we had at the trial, is that it's like, well, what were you thinking? You know? Did you speak to the jurors after, and did you get a sense of, like, what did they find compelling at the trial, or what did they think about the defendants? You know, like I said, these big companies, Monster and Coca-Cola. Yes, we did speak to the jury extensively after the trial. In addition, defendants, as is very common, it's a typical procedure, as you know, to move for a new trial and judgment notwithstanding the verdict. They've done that. So we did, interview most of the jurors, not all of them. They did not find that the defendant's witnesses had credibility. And they found that the arguments of the defendants did not have credibility. They were inconsistent. That was another theme and another argument that we were able to make to the jury, is that on one hand, they're telling you something here, and then on the other hand, they're telling you this. The arguments, it didn't make sense on a number of the issues that they had to prove. It just didn't add up. And so you're thinking, well, then why are they making this argument to me? I mean, you're sitting there listening to it. We're sitting there listening to it. And we're the attorneys thinking, why is this argument being made? You can imagine, to see someone being cross-examined with incredulity, because it was incredulous at times, some of the statements from these witnesses.
Did you think that the jury already had a feeling of not believing these big companies because they're so big?
No, that was something that, even during closing argument, I made a point of saying, nobody is saying that corporations are 100% bad, right? No one, these corporations employ people, right? They're good corporate citizens. And that is the case for any case involving a corporation, whether large or small. They serve a function in our society. It's not just an anti-corporate theme or statement. In fact, we were very careful to stay away from that, because the reality is that most of the jurors actually were employed by large corporations. And in fact, San Diego is a bit more of a conservative community. The military is there, obviously, at Coronado. And then there's a lot of defense contractors that employ large percentage of the community. So it's a very interesting community, very diverse. And there was a very diverse jury, and we had to be careful, and we were careful, because we don't want to come in and have some anti-corporate bias. The facts are what they are. The facts spoke for themselves. And the truth was that, yes, not all corporate citizens are bad citizens, but some are, and here they are, right here.
Here they are. We have
a good point. Just for me to interject really quick. This is so fascinating. I'm really learning a lot. But I wanted to keep an eye on the clock. We're about to end in about 2 minutes. We're set to finish at 11:45. So Doris, if you have just one closing final question for Jordana. Thank you so much to both of you. This has been just a really valuable time.
I think I'm going to pick one of the questions from the Q&A. Were there any experiences during your time at USF that you really pulled from during your work on this case? I think that's a great question.
It is a great question. And definitely that non-suit motion. Because that was, I remember just being in there, just being stunned. Like, what is a non-suit, and why is it happening to us? Like, what did we do? And we hadn't proved the age of the plaintiff in that. So I even told Jordan, the associate I worked with on so closely with this, I was like, we cannot have a non-suit. So let's make sure we go through all the elements. And so every day after each day of the trial, our entire team would sit down, and I made up a chart with all the elements that we had to prove. And I would put in testimony every day and hey, we got this one. Okay, now we got to hit this with this witness, and I did that every day. And I did it after, every weekend I'd sit down like, okay, what do we have left? What other can we supplement with this? And that was actually very helpful during the closing argument as well, in preparing that, because, we were able to draw from a lot of that testimony. It was right there. So that was definitely one thing. And I would say also, being at USF, I was raised with no religion whatsoever. I don't know. I don't think I'm necessarily atheist. I really don't know what I am at this point. But, I had never gone to a Catholic school or anything of that nature. And when I went to USF, it was explained to me the Jesuit philosophy of education and of service. And that's something I just have brought that to my practice. To serve people, to stand up to bullies, and to serve people in making sure that their rights are protected. That's really the core of the philosophy that USF instilled in me at USF Law. And so, yeah, I think that's what I take with me every day.
Well, I think that's our time, right, Carolyn? And wow, so fascinating to hear the story of the Hanson family and your incredible work on it, especially the things about the trial. And I really couldn't get over 150,000 in sanctions. And so we had to cover that. But God, if we had another hour, we'd talk about this trial forever.
Yeah, I could for sure. Thank you so much.
Thank you very much. And thanks to USF for bringing us back together again. And let's keep connecting with each other.
Yeah, sounds great. Thank you. And thank you to everyone watching, and stay safe and clean.
Absolutely. Thank you so much to both Doris and to Jordana. This was a really valuable time, and thank you for your time. And thanks to each of the attendees who joined us today. Just as a reminder, we'll be sending you a copy of this so that you can watch again or share with others who you think would find this really valuable. So thanks to all of you. Be safe and well.
Thank you.
Thank you.